So, first question, of course, I just want to ask you real quick. What is the purpose for you wanting to reach out and talk to us today?
Just I represent Mr. Wilcox, who is accused in this failure to report case, and I wanted to kind of give a roadmap to everybody as to what our plan is and how we're going to proceed forward in dealing with these allegations.
And so, whenever the allegations were first popping up, there was a dismissal by your client on July 9th about the coach that had partaken in a alleged improper relationship. Why did Brian dismiss the allegations at those times?
Well, understand that the way it works in the United States and the way it works in the state of Texas is that all people are presumed to be innocent. And Mr. Cox, my client, Mr. Wilcox rather, is going to he's going to plead not guilty because he's not guilty of this offense. And we look forward to getting a jury trial as fast as we can and present the evidence in our case.
And so he is pleading innocent, as you mentioned. Um, but of course, whenever these issues had popped up, what was the sort of dismissal, of course, with the evidence that it came out later on? What was the cause for the dismissal of these issues and why that happened? Of course, with his role as a superintendent, it is upon him to report these things as they happen.
Sure, all the issues that you and I are discussing, we have a word for that. When you're dealing with an allegation that's made by the government, it's the government's burden of proof to establish beyond a reasonable doubt that a person is a wrongdoer, that they've committed an offense. And what you're talking about is what we call evidence. And in this case, it's going to be up to the state of Texas to present this evidence in a courtroom and convince a jury beyond a reasonable doubt that this had happened. It's our position that Mr. Wilcox is not guilty of this offense. And this evidence that you and I are discussing is going to be up to the state of Texas to present what they think, if they have it, that could convince a jury beyond a reasonable doubt that he had done something wrong.
And of course, the allegations that have been talked about, as we were just talking about, that was one of the things. But there were people who were, of course, posting on Facebook. It is very active in that area. Screenshots that were reported to be sent to him. Why was it that he wanted to dismiss those screenshots and wanted people to talk to him in person instead?
You know, there's a lot of things that are out there in social media world, but whether it's social media world or what somebody told somebody or said something, once again, we call that evidence. And it's going to be up to the state of Texas to garner all that evidence, if they can, and attempt to convince a jury beyond a reasonable doubt that my client committed this offense, which is our position that he didn't, that he's not guilty of this offense. Regardless of what your position is, he's afforded the same presumption of innocence as any person is in the state of Texas in the United States. And we look forward to presenting the case to a jury because that's what the game plan is. My client is not guilty. We're not going to be pleading guilty. And we look forward to seeing what the state is going to offer a jury to try to convince them otherwise.
And so basically what you're telling me is that he denied these things because it's up to the government to be able to look into it instead of him.
I can tell you, sir, the reason that he denied these things is because he's not guilty. Didn't commit this offense. And we absolutely believe that if you get any reasonable group of people, that they're going to feel the same way, that this man is not guilty of this offense, just like he's pled.
And it is, of course, by the marshals reported that uh, he's not the only person who's alleged in this case. Did he work with other Winnsboro ISD employees to interfere with this investigation in any way?
You know, I'm here. I can't speak as to anybody else. I'm here to speak on behalf of the former superintendent. And so that's the only person I can speak to. But I can tell you that we have conducted an investigation in this case. We believe our client that he's not guilty of this offense. And we look forward to seeing what the state would plan on offering to convince a jury otherwise.
One of the people that have been talked about in this case is Heath Guy, he is a name that's popped up in this. Was this in any sort of retaliatory action to Heath Guy and what the investigation that he did that was brought to your client's attention?
A witness's motivations as to whether or not why they would say one thing or another, once again, falls into the category of what we'd call evidence. And evidence is not something that's presented on social media. Evidence is not something that's presented on a radio program or a news show or even a newspaper. Evidence is what comes into a courtroom, is deemed admissible. And so that's what we look forward to seeing and hearing.
And of course, you're talking about evidence, but did he or did he not? Was this any sort of retaliatory action in what you have found? Do you feel like your client had any sort of retaliatory action against Heath Guy in this case?
Yeah, once again, motivations, why was a person doing something? What were they doing? What were they were thinking falls into the category of evidence. Evidence is what is deemed admissible in a courtroom for either a judge or a jury to hear.
And the allegations that were brought forth against the substitute teacher, why did he dismiss those allegations?
Once again, it's like an allegation, a dismissed allegation, all of that's going to fall into the category of evidence. And evidence is what's presented either to a judge or to a jury. And so that's how our system of justice works. Whether you're a superintendent of a school or anybody else in the state of Texas or in the United States. And I've been doing this quite a number of years, and that is how we try cases, is we deal with evidence.
And of course, the wardens and other parties have taken their own investigation and, as you've mentioned, brought up and gathered evidence. Your client, he sort of undertook his own investigation into these claims as well, correct?
Well, once again, investigations and what went into an investigation and how investigations were done, those are things that either come into evidence or don't come into evidence. There's a threshold for that. And so that's what's going to happen in a courtroom in this case.
And just in your mind, yes or no, did he or did he not go through with an investigation on his own to ensure that these things were done?
Once again, whether or not investigations had taken place, how the investigations were handled, what was looked into, what witnesses were spoken with, all that's evidence. And we don't try cases. When you do what I do as a trial attorney, we don't try cases out on television. We don't try cases in the newspaper. We try cases in courtrooms. And, people certainly can say things to people. They can put things on social media. They can do all kinds of things. And that's the beauty of living in a country like the United States and the great state of Texas, is that allegations aren't enough. The government has to prove beyond a reasonable doubt that a person did something wrong, that they violated the law. And it's our opinion in this case that there isn't evidence of that. And that's why we look forward to getting this case in front of a judge or a jury as fast as possible for me to clear my client's good name.
And whenever these initial situations were brought to light about the two different cases with the substitute teacher and the coach, whenever they were brought to his attention, why were they not reported right away as it is stated?
Like I said earlier, whether or not something was reported, a report was made, wasn't made, that's evidence, if admissible. And it's important to keep in mind that it's what's presented in a courtroom. It isn't about conjecture or speculation. It's about evidence. And my client is not guilty. He's pled not guilty. And we firmly believe that the evidence in this case is going to support that idea.
And as you mentioned, you believe your client is not guilty. Do you believe that he reported these things in a timely manner?
Like I said, the reporting is part of whether there was reporting, not reporting, those are questions that a jury or a judge is going to decide in a case, because we call that evidence like everything else in this situation.
And Mr. Wilcox resigned in his position there. Did that have anything to do with this case in particular?
The thing is, when you deal with something in a situation, in any situation, the question that a judge or a jury is going to have to decide, or really a judge, is whether or not something is relevant. And the definition of relevance is a fact and consequence that makes, or an issue that makes a fact and consequence more or less probable. And so that's what, determines whether or not something's going to come into the trial. Because that's really, we can talk about all kinds of things outside of this, but what it comes down to is what's going to be presented in a trial, what's going to be an admissible piece of evidence which makes a fact more or less probable in the allegation. And so we look forward to that being presented to a jury.
And this is a question not about evidence, but why was it that your client resigned from his position back in September?
Once again, if the issue as to whether or not a person had resigned from a position is relevant, that's going to come into the trial. That's what's going to happen. And ultimately, decisions like that are going to be made by the judge that presides over this case.
Um, for Mr. Wilcox, of course, in his position as superintendent, did he feel like he did everything to protect students in this case?
Once again, a person's motivation, what they did, what they didn't do, ultimately we can talk about that. But when there's been a formal allegation made by the state of Texas or any government agency, the question is whether or not the government can prove that beyond a reasonable doubt. That's what this whole thing comes down to. You and I could talk about any person's life, different things that they did, why they did them. But when you've gotten to this point and the government has accused you of doing something wrong, the purpose of you and I talking today and me talking to all your viewers today is to talk about this situation. That this is about a criminal allegation that's been made against my client. And so the question is to the state of Texas, what's your evidence and how are you going to prove this beyond a reasonable doubt? Beyond a reasonable doubt, it's the highest burden of proof in our justice system. You don't want to guess a person guilty. And we look forward to these issues being presented to the jury and let them decide. And so you and I could spend hours talking about different aspects of a person's life. But once you've been put into the gun sights by a government agency, that's what needs to be discussed is what does it take to present a case? What's the burden of proof? And what is your client's plan? Is either going to plead guilty or not guilty? And I'm here to tell you that Mr. Wilcox is pleading not guilty because he's not guilty of this offense. And we look forward to listening to the state's presentation in this case to see if they can convince a jury otherwise. It's our position that that they won't be able to because my client's not guilty of this offense.
And as you mentioned, he is not guilty. Do you feel like he has fully cooperated with law enforcement throughout this entire process?
Once again, that's going to be a question that has to be determined. Those kind of things would have to be determined by the judge that's going to preside over the case. What did a person do? What did they not do? And then it comes back to what we discussed a little bit earlier. Is it relevant? How does it make a fact and consequence more or less probable? And what constitutional issues had factored into how a person conducted themselves? That's the issue with any case. I've been trying cases throughout the great state of Texas for 27 years. That's always the issues in the case. And it's not going to be any different in this case. Whether or not you're in Texarkana, whether or not you're in Brownsville, whether or not you're in Midland, whether or not you're in El Paso. It's the same thing in the state of Texas, and it has been for the entirety of my career.
And just simple yes or no, during his time as superintendent, do you feel like your client properly took care of all of the things that were presented to him in this case?
Like I said, I'm not going to be one of the jurors in the case. I'm the lawyer, so I'm going to be sitting at counsel table. And so, frankly, my opinion on things is not relevant. And the judge is going to determine what's relevant, and then it's going to be up to the jury to get whatever weight they want to that what's going to be presented to them.
Just wrapping up, is there anything else that you feel is necessary to add or that I have not asked about that you feel is important to clear up or add?
Absolutely. We look forward to our day in court. My client was a respected member of the community, and this has just rocked his world. He takes it completely seriously, obviously, and we look forward as soon as possible to getting this case into a courtroom and having a jury listen to the facts of this case and make a determination as to whether or not the government has proven their case beyond a reasonable doubt. It is no small thing when the government makes an accusation that can deprive you of your liberty. And you have to have your ducks in a row, you have to have your I's dotted and your T's crossed in order to take a person's liberty away from them. And we believe that our client is not guilty. He's presumed to be innocent. He's not guilty of this offense. And we look forward to getting this case in front of a jury as fast as possible.
Alrighty, I appreciate your time. If I have any questions, I'll email you. I have your number as well. So I appreciate it once again.
Yes, sir. Thank you.
Yes, you have a great day.
You too.